crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis Wright.
Hello and welcome in to the attorneys. Appreciate you being with us tonight. We have a topic of conversation that every time we do this show on this topic, the phones, the email, everything lights up. This is one of those topics that it seems like folks are always in need of some advice on, and it is family law and divorce. So if you know someone who just you think may benefit from the show tonight, you might want to give them a call and a heads up and say, hey, tune into the attorneys, a topic I think that will be helpful to you because we've got a great expert on to help lead us through this conversation and kind of the waters here of family law and divorce. Before we get to introductions, a reminder, all throughout the show on the bottom of your screen, ways you can call, text, email. Also, Hollis Wright Mix available each and every Sunday night. Attorneys standing by live for you to speak with. That free, off-air, and confidential conversation is yours. It's available all throughout the program tonight. Alwin Horn from Hollis Wright is leading our conversation. Good to see you, sir. How are you?
Good to see you, David. It's always good to be here.
You got those glasses. You look super smart. You're dialed in tonight, aren't you?
I need them. I need them. Age has caught up with me.
I hear you. I hear you. So our topic of conversation, family law and divorce?
And fortunately, we have Mr. Brad Latta here. Brad, we've known him for several years. He's been practicing in the state of Alabama and in the area for about 15 years. And Brad, if you would, just introduce yourself to the audience and let them know what you do.
Sure. Thank you for having me on. We do family law and divorce primarily. That's about 100% of our practice all throughout central Alabama. Anything from child custody, divorce, adoptions, juvenile cases, child support, alimony, anything like that.
And Brad, you've mentioned several topics, and we've got a lot of them listed here we're going to talk about. Let me just ask you this. You've done this pretty much your entire career, is that right?
That's right.
And what has made you stick with it? What do you like about it?
I like forming a relationship with our clients. It's very personal work. We really get to know our clients, and we have a personal relationship with them. And they appreciate that. And sometimes it can be a little hectic, but it's fun. We enjoy it.
I imagine so. Well, let's just jump right into it. Something that I've noticed, we get these calls, and of course we don't specialize in this area, we refer them to you. But what seems to be two of the biggest concerns amongst folks that might be going through a divorce or about to is what's going to happen with my assets and my property, and where are my children going to live if this happens, if we get divorced? Can you let us know what your thoughts are on that?
Sure, yeah, the laws haven't changed on that. So even though divorces are kind of on the uptick a little bit right now, the laws are the same. So when it comes to assets and division of debts, it's always going to be what the court thinks is equitable or what's fair, which is very subjective in a gray area. But just in terms of houses, property, cars.
And break it down kind of like that. What's meant by, because you have alimony and you have child support payments, and those are monetary payments, but then you have assets such as real property, vehicles, maybe retirement plans, things of that nature. Break it down a little bit for the audience, if you can, about how those may be calculated, what the difference is between real assets and monetary payments.
Sure, yeah. The real assets, the main one is usually the house. And the parties have to decide what they're going to do with the house, if they're going to sell it, if one party's going to stay in the home. So it just really depends on the individual circumstances of what's going to happen with the house. The market is pretty good right now, so a lot of people are willing to sell the house and split the equity, things like that. In terms of the monetary payments, if there's minor children involved, the state of Alabama has guidelines for what the child support is. So it's a formula we use, and we just put the numbers in, and we have a chart, and it just tells us, based on y'all's incomes and health insurance and daycare, this is what the child support is.
You referenced the word, or we've talked about the word equitable division of the assets. Does the party's conduct, whether the wife or the husband, to-be ex-wife, ex-husband, does their conduct, which led up to the divorce, ever affect how the judge may rule or divide the assets?
It can, yeah. And we have to caution our clients to be careful sometimes. If one party wants to make a claim for the house, for example, we don't want them to leave the house because then it can cause problems. So what they do during the marriage is very fact specific to each individual case. The judge is going to do what they think is fair, and that doesn't always mean what we think is fair or the other side thinks is fair. It's what that judge on that day thinks is fair. But the judges that we have here are very good, and they really, we like to say nobody wins a divorce. Both parties usually walk away not loving the outcome.
If neither party's happy but both are content, then it was successful.
Exactly.
I understand. Well, tell us a little bit about how the alimony payments, and first of all, define what is alimony. I mean, I'm curious, does the working party, or if both parties are working, pay alimony? How is it decided which party pays the alimony, and how's that determined?
Yeah, there's several types of alimony. There's, alimony and spousal support, same thing. The terms are interchangeable. It was designed years ago if a party got divorced and typically the wife had stayed home and raised the children and the husband went out and earned income and then they got divorced, the husband would still have the ability to go earn income, but the wife either had little education or no work skills, and so it was designed to balance out the incomes of the parties. Nowadays,
things have definitely changed,
yeah,
especially given the women workforce
absolutely.
today.
And there's several types of alimony. You can do a lump sum, which is where you just write somebody a check and that's it, or you can do a periodic, which is monthly payments for a set number of years.
Let me ask you that right here. Speaking to the lump sum, because you hear are periodic payments typically ordered by the court, whereas a lump sum is typically an agreement made between the parties?
Generally, yeah, I would say so. Typically, with a lump sum, we look at retirement accounts. If one party has a 401k and the other party doesn't, that can be used to balance out that a little bit.
Well, you brought that up. Let's ask about that retirement account. Is that not an asset that would be divided equally between the parties? Okay,
yep.
Okay.
And the laws on that have changed recently, depending on the length of the marriage, the part that was contributed during the marriage versus prior to the marriage. So the rules for that are very specific in how that gets divided up.
Okay.
Before we got about a minute before we have to head to break. I want to get in this question though. My father started a business that I now own since my father's retirement. If I file for divorce, will I have to split my business with my wife who has worked there for years?
Well, the favorite answer that we always say is it depends. Very fact specific. It depends on if they worked in the business, if they have an equitable interest in the business. They can make a claim to a percentage of that. And so it's always best to just talk to an attorney who knows that kind of work, and they can really delve into the facts and figure out, is there an ownership interest, and how do we go about making that fair for everybody?
Yeah, so the details in a case like that, they're really going to come into play there. All right, let's step aside. Let's pause right here. Our first break of the evening, again, talking about family law and divorce. And hey, if you are on social media, you're going to want to check out Hollis Wright on social media. Everywhere you are, they are, and a fantastic educational and informational resource. Just search Hollis Wright, whatever your social media preference, and you'll find them there. You're certainly going to want to give them a follow. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, That's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back into the attorneys talking about family law and divorce. Before we get back to our conversation, a reminder, attorneys from Hollis Wright are standing by live right now. So if you want to take advantage of that, go ahead and pick up the phone and give them a call. Allwin?
Thank you, David. All right, Brad, we're back here, and you've done a great job of kind of discussing and explaining to the audience what the obligations of the parents will be to one another when divorcing. But let's talk more about what happens with the children, I guess, which is referred to as child custody. Is that right?
That's right.
Generally speaking, I mean, I guess this can be done maybe by an agreement or court order. How does that work out in terms of who gets custody of the children and where they're to live and things of that nature?
Yeah, again, it's very fact specific. We always try, if we can, to get an agreement between the parties and not involve the court as much as possible. If the parties just can't agree on the custodial arrangement or visitation, then we do have custodial schedules, standard visitation. There's an out-of-state visitation schedule if a party lives out of state. And if the parties just can't agree, then most times the judge will just order that schedule.
Tell our audience what would be considered the standard or general practice of visitation or custody.
It's generally every other Friday to Sunday, usually Friday at 6 p.m. to Sunday at 6 p.m. There's a lot of time in the summer, usually 4 or 8 weeks in the summer. Spring break, holidays are divided, Thanksgiving, Christmas, Mother's Day, Father's Day, the birthdays of the parties and the children. So it's all on the schedule, down to the times and the pickup locations, and everything is in the schedule.
Does the court generally follow a set precedent as to which parent will maintain the custody? Or is that fact specific and dependent on what's transpired to lead up to the divorce as well?
Yeah, it depends. The legal standard that they use is what's in the best interest of the children. And again, that's kind of like equitable division. It's just what that judge feels like on that day. Sometimes the parties, if we have a trial, the parties will testify and there's evidence presented about which parent should be the primary custodial parent. Just depends on a lot of factors, the parties' work schedules, who the children have been living with, where the parties live geographically. So a lot of things go into determining that.
And I would assume it's in the best interest of the children also to keep them out of the divorce process as much as possible and to come to an agreement.
If possible, yeah, we try to do that.
A question we got here about medical insurance relative to a divorce. The question is, can a court order that my husband keep medical insurance coverage on our children until they reach 18 years of age?
They can. Yeah, and actually now with the new Affordable Care Act, it can actually go to age 26. So that's a very common thing that we put in almost all the agreements, and it's in the order. One part, the kids have to be covered on somebody's health insurance, and it just depends on, if the father, for example, can get it through his work, and their kids are already on that. That's a good way just to keep that in place. If the mom has them on her plan, we can keep them on that plan. So the court doesn't really have a preference which way or the other who covers them, just making sure that they are covered by at least one party.
Let me ask you this. Speaking of that, we've talked about determining amounts of payments and alimony, child support, now this health insurance and medical expenses. What happens if there's an agreement in place and the situation changes where the responsible parent loses a job or is remarried or things of that nature? How can that affect, or what would the parties do to change the original agreement if possible?
It's always possible to change the agreements, especially ones that involve children. The only things that can't ever be modified by a court are property settlements. One-time property settlements can never be modified, but everything else pretty much can. And those are more common for us than new cases. So we do a whole lot more going back and modifying previous orders or filing to enforce a previous order if somebody's not doing what they're supposed to do. But it's very common. People move, people change jobs, people get remarried. Kids grow up. I mean, just, life happens, and it's always easy. There's a mechanism in place for going back and getting that modified.
Is there an age or certain circumstances that arise where child support payments or alimony are no longer the responsibility of a parent?
There is, yeah. Child support automatically stops when the child turns 19. So absent some other provision that the parties have agreed on to keep paying past that, which is rare, it just automatically stops when the child turns 19. So you have to go, if you have other children involved, if you have one that turns 19 and then there's younger children, you have to go back to court and open that up again and recalculate the whole child support again to get the new number to take one of the children out. Alimony is either by agreement of the parties for a set length of time, or it's whatever the court orders. Generally, a guideline is they will order it for the length of the marriage. So if the parties were married 10 years, it would be common to see an alimony in place for 5 to 10 years, something like that.
And you've referenced calculations and how to determine the amounts of child support, and I guess that's relative to each family's income.
Yes.
Is there any general rule of like what percentage that typically comes out to be for a responsible parent?
For the child support?
Yes.
Generally between 20 and 25%. It just depends on, it's higher. The chart starts at one child and it goes 2 children, 3 children, 4 children. So it keeps going up and then goes up based on the incomes of the parties, the combined income of the parties.
Okay.
So the higher the income and the more children, the higher the percentage is going to be.
Question we've got here, what can I do if my ex-spouse is not providing court-ordered child support and alimony?
Like I was talking about before, going back and taking them back to court to get that enforced. It's a petition to hold them in contempt of court. If they're not following what the court order says, if either party's not following it, then the other party has to take them back to court to ask the judge to hold them in contempt to kind of make them do what they're supposed to do.
What would happen if the responsible party is held in contempt, but they still don't abide by the court order?
I've had judges that will put them in jail.
Are there ever excuses to where a judge may deem there's some type of economic or financial hardship that would justify?
There is, yeah, especially the last year with COVID, people are losing jobs, and judges don't want to put people in jail for doing that. It's kind of a last resort, but they will if they're not going to follow the order. But they try to work with them as much as they can.
All right, let's step aside our second and final break of the evening. As we do so, just a reminder, those attorneys from Hollis Wright standing by live, so you've got just a few minutes if you want to take advantage of that opportunity. Stay tuned. More of the attorneys coming right up.
I'm attorney John Spade with the Hollis Wright Law Firm. If you have ever had a personal injury claim, the attorney handling your case has likely told you that a portion of your settlement would have to be used to pay back your health insurance company for the medical bills that they paid relating to your injuries. This is called subrogation. In this week's Legal 411, we are answering the question, what is subrogation and how does it affect your personal injury claim? When you purchase health insurance, you sign a contract with the health insurance company, which provides that in exchange for you paying a monthly premium, the insurance company will pay your medical bills when you're injured. Now, that contract has a paragraph that gives your health insurance company the right to seek repayment for the medical bills they paid if you in turn use those medical bills as a basis to recover from a third party that caused your injury. The idea is that your health insurance company would not have had to pay your medical bills if it weren't for the wrongdoing of the third party. Now, health insurance companies routinely put attorneys on notice of their subrogation claims by outlining exactly which medical payments the health insurance company is claiming a subrogation claim for and for what amounts. Throughout the handling of your case, your attorney should be aware of the amount of subrogation your health insurance company is claiming and whether all the claimed subrogation is related to your underlying personal injury case. That way, if your case resolves, your attorney can then negotiate a reduction of the health insurance company's subrogation claim. Subrogation is one of the many moving parts that can affect your personal injury settlement and what you stand to recover. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into the attorneys. This is our final segment. So if you want to be involved in the show, that information at the bottom of your screen, take advantage of that. Also, the attorneys from Hollis Wright are standing by as well for the next 8 minutes, about 8 minutes. So take advantage of that opportunity as well, talking about family law and divorce. The question we've got here, my ex-wife wants to relocate with our child who we share custody of. Is there a way I can stop her?
There is. Yeah, we have what's called the Relocation Act. It's a statute from one of the laws on the books in Alabama, and there's very specific requirements if a party wants to relocate more than 60 miles from their residence or out of state to another state. They have to send notice by certified mail with a whole list of things. You got to do it exactly by the book, or it can trip you up, and they have to serve that on the other party, the non-custodial parent. The non-custodial parent has a time frame once they get that they can file an objection with the court to prevent the relocation. And the judges will set it for a hearing, and the parties will go and argue why they should be allowed to relocate versus why they shouldn't. And the judge will decide.
Brad, I would assume that since it's your children involved, that despite the fact that most divorces are probably hotly contested, that's a very hotly contested issue.
It is.
What are some of the special circumstances that arise that would make somebody want to relocate, and how often does the court allow that to happen?
We like to say there's good reasons for relocating and there's not so good reasons for relocating. If you're wanting to move in with an elderly parent who's sick and take care of them, that's a good reason. If you want to move in with a boyfriend or girlfriend in another state, not generally a good reason. So it just depends. If your job transfers you to another location out of state and you can't get another similar job closer, that's a pretty good reason. But it just depends. The court has to weigh a lot of factors. They want people to have the freedom to live where they want and work a good job. But if they're taking the children far away from the non-custodial parent, that affects their custody and visitation. So,
in regards to going to having these hearings, doing the civil litigation, personal injury type work that we do, we engage in discovery a lot, which is basically the taking of depositions, going and finding witnesses. Yep. Sometimes you hire investigators to look in to see if these allegations or accusations, for example, facts needed to relocate, are in fact true.
Yes.
Do you all engage in that type of activity in order to prepare for a hearing?
We do.
To fight it or consent to it?
Yeah, same as on the civil litigation side. In generally, more contested divorces where the parties can't get an agreement at the beginning, we'll exchange discovery, interrogatories, requests for production. It's different than the personal injury side because we're exchanging birth certificates and check stubs and tax records and social media posts and things like that. But it does help the parties sometimes come to a settlement. If not, then it lets us prepare for trial because we have all the evidence.
I'm curious. I've had friends and family members both go through divorces, and none of them have been friendly. I don't even know if there's such a thing as a friendly divorce. Like they kind of emotional. Yep. And in every case, the person you're close to, you're on their side. Like I haven't been able to give them objective advice. Do you find yourself having to be the one to give them some tough love and just kind of to be honest?
Yep.
Regardless of what you say, think, or believe, here are the facts?
Absolutely. And that's a big part of what we do is kind of educating them and walking people through how the process works because, most people know somebody who's gone through that. Mm-hmm. But unless you're on the inside, all you've kind of heard is, hearsay or third party. Right. You don't really know till you're in there. And so, just kind of letting them know and setting the expectations from the beginning. Some divorces can be real ugly and messy, but a lot of them aren't. And really? The parties can come to an agreement and it can be amicable. So just depends.
Let me ask you this one question while we're still on the relocation issue. Let's say a parent does not follow the process or procedure and they do move away with a custodial child to a different state. How does the non-custodial child get them back?
Well, you would file with the court and let them know. The judge would set it for a hearing. And if the other party has been served and they don't show up, the judges that we work with would probably go ahead and change custody then. If they haven't followed the rules, then they're very specific on what you have to do. And if they just do it on their own, it's not going to go well.
Well, you've done a really good job of explaining that. Let's change topics here a little bit. In regards to some of the things that have to be divided or paid, are retirement plans divided among the spouses upon divorce?
They can be, yeah. Depends on how long the parties have been married, what percentage they contributed during the marriage, the balances of if each party has an account, what those balances are. If they're roughly the same, then the court's not generally going to disrupt that. If one party has a whole bunch and the other party doesn't have very much, and it's a pretty lengthy marriage, then that can be balanced out a little bit.
What is the duration where it does become, I guess, a marital asset for division?
It used to be 10 years. That used to be the
Okay.
hard line. Now the law has recently changed where there's no 10-year requirement anymore. It's just up to the judge. And so they'll take it just kind of puts more in the hands of the judge. They're going to consider all the situations, the length of the party, misconduct of the parties during the marriage. If one party's drained out their retirement account before the divorce, that's going to be figured in. So, it just depends.
We are just about out of time, less than 2 minutes remaining, but I want to give both of you time for a final thought. And Brad, if you would, you go first, please, sir.
Yeah, sure. We offer free consultations. We're doing a lot by phone, Skype or Zoom, or you can come by the office. We do 30 minutes to an hour, no charge at all. Just kind of go over your case and see if we can help you.
And I'll just say this, of course, if anybody calls our firm and I end up on the phone with them, I'm sending them to Brad. Because, I can't say I envy him being involved in these personal matters, but I'm more power to him, and we really appreciate you being here.
Thank you.
Yeah, always helpful. And these are those shows that a lot of folks, but we got just a minute remaining. I'm curious, one thing we didn't get to, college education. We had a question about, can you make someone pay for that? Can a spouse or a court, can they do that? Can they make someone pay for education, college
Not
education?
anymore. The law on that changed a couple of years ago. A case came out from the Supreme Court, can no longer be ordered. Now the parties can agree,
right?
If they just have an agreement in place, but they can't. The court can't order one party to pay post-education.
Yeah, and that's the value of having some legal advice and somebody to ask about that for sure. Brad, appreciate you. Good to see you again.
Thank you, too.
Thanks for Ms. Allwin. Thank you very much.
Thank you very
sir.
much. I enjoy being here.
It's always fun when you're here, and it's always enjoyable for you as well. A couple of reminders just before we let you go. Don't forget Hollis Wright on social media, all over YouTube, Facebook, Instagram, just everywhere. You'll find topics like this, and maybe you know someone who might benefit from watching tonight's show. It's on YouTube. It's on our website. Just search Hollis Wright, and you can find it there. Maybe this is the type of show that would be beneficial for you to kind of copy and paste that clip and send it to them, maybe to their benefit. We appreciate you being with us, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.